right? So there's this period of time where after a person has passed away, there might be a will, but nobody's petitioned the court to get it admitted by the court or anyone appointed as executor. And so what you have to do is you have to petition the court to validate the will. So you're in an application, you're just telling the court, hey, I'm the named executor. I'm qualified as executor. This will names me as executor. I think this is the valid last will and testament of this person. And we need to administer the estate, meaning we need to gather all of the assets, pay any creditors, and then ultimately distribute assets to the named beneficiaries. So you're telling the court that, and then you're delivering the original will to the court. There's a different procedure for probating a copy of a will. So you want to deliver that original will to the court. And then ultimately, you're going to request a hearing, right? We're going to have a hearing where you get certain testimony in to validate the will, to prove to the court you are able to serve as executor. There's nothing disqualifying you for serving. And this is what's known as the prove up hearing. In Austin, we have these in person. In Bexar County, we have these via Zoom. And there's some other counties around the state that still allow this via Zoom. So we have our probate hearing. And then after which, hopefully the court signs an order admitting the will and appointing you as executor. And then you get your quote letters testamentary. Those letters are what allow you to act on behalf of the estate. And then within 30 days, you have to publish a notice to creditors in the paper. We typically do that for you. Within 60 days, you have to notify any secured creditors, right? This is typically a note on a vehicle or a mortgage on real estate. And then within 60 days, we also have to notify any beneficiaries that exist that you were appointed, an estate is opened, and here's a copy of the will that was admitted. And then within 90 days, unless there's an exception, and typically there's not, but you'll have to submit a full inventory of what all estate assets exist, right? Not any creditors, but just what the estate holds as far as assets. And then you look at distributing the estate. So that's a kind of brief overview of what an estate administration looks like. And so when someone wants to avoid probate, that's what they're trying to avoid. So I hope that's helpful in kind of giving you an outline of what's going on in the probate process. Now, I want to comment on one additional thing. A lot of people come to the office thinking, oh, I'll just talk about estate planning for the kids, right? So a married couple comes in and they're focused on what they want that to look like for the kids. But you really need to think through what you want that to look like for your spouse as well. Because oftentimes your spouse will need to probate their spouse's will as well, even if it's just to transfer ownership interest in the house or real estate. People assume, well, we're both on the deeds, the deed or deeds, and so it automatically passes to me. That's not necessarily the case, right? You have to take some sort of action to transfer your spouse's interest to you if you are the surviving spouse. Just because you're on the deed does not mean that you will automatically get your spouse's interest. And if you have stepchildren, it could be, and we see this often, that you as the surviving spouse will now own your house with your stepkids. And so, there's very easy ways to avoid that, one of which is probating the will or having a joint trust that transfers ownership of the real estate to the surviving spouse. So you just want to think through those options. All right. Well, thank you for joining us. I hope that brought some clarity for people. And we will talk to you soon.